Welcome Srinivas sir to 16th International Residential School 2024, Kathmandu School of Law. This is a flagship program of Kathmandu School of Law. And we have been, if we continued it during the COVID period, it would have been 2 decades. We had a long gap of around 5 years. So, like we discussed before, we'll be talking about TWAIL and connecting it to this year's theme, that is decolonizing law and justice. So I think decolonizing international law is related to TWAIL, right? And how do you consider TWAIL as playing a very big role in decolonizing international law till date?
Thank you, Amritha, for having me here. I think TWAIL is very closely related to this year's your theme of the program and the school that you are running. Yes, of course, there are immense work has been done so far. Of course, earlier it was not much work was there, but in the last 2 decades or so, there's a lot of work which has been done in the field of TWAIL and, of course, touching upon various issues. But still, history remains central to the work of TWAIL, at least so far, if we compare with TWAIL scholarship in relation to other branches of international law. I think the history part has been fairly covered. And when we look at the history part of it, the central dimension of the history, which is closely related to TWAIL obviously, is that the process of colonization that took place and how international law played a significant role in colonial project itself. So it's not that something that international law is used as a kind of an instrumentalist way for the purpose of colonization, but it played an extremely important role in terms of even developing certain categories. So that is what the major work of the TWAIL so far has been, and especially after Tony Angi's work, the whole idea of engaging with the question of sovereignty and how it was used for the purpose of colonization itself as a legal category. So these are some of those areas which otherwise used to be considered as a central conceptual frameworks for the mainstream international law, even for the doctrinal understanding, are subjected to kind of a critique, particularly with the methodological approach of third world approaches to international law. Now, so in that sense, of course, the history is closely related to the TWAIL project, and history is closely related to the international law's decolonization one, because if you see some of those, the categories like sovereignty, the category of a state, the category of citizenship, in fact, which are individual, I were to put it that way, all of them which are generally seen as part of neutral categories without any political influence, purely as legal categories, are actually political, and also there are economic dimensions to it. Now, this opening of the possibility of critique of these fundamental concepts of international law has been done in a big way, at least by the TWAIL scholarship. And probably if you look at a little more carefully the critical approaches within international law in the last 3 decades or so, at least it is probably, I think I may be corrected, but I don't think there is any major critical approach to international law in the last 30 years after feminist intervention in 1990s has happened. There is no other critical approach in the last 30 to 40 years which kind of subjected international law to a serious critique. Probably that has been, I think, done by TWAIL. I don't think any other approach has done in the last 3 to 4 decades the way TWAIL had done it. Yes, Marxist approaches have done it, but they have been there. It's not that something that they have just emerged in the last 2-3 decades or so. Policy-oriented approach dominated for some time in North America. New Haven School. So like that, if you see, there were critical legal studies, of course, it started predominantly in the US domestic law context, but it has been borrowed into international law. But all of them, more or less, like by 1990s, really there was nothing much was happening in terms of critique, which then feminism came in some of the important writings as a feminist critique of international law. But during this roughly same time, in 1990s, if you take the first TWAIL conference from 1990s. So from then on, the amount of scholarship that has been produced through this 12 critique, because I don't think any other critical approach has done it. So in that sense, I think the 12 remains as a very important critique even now. So yes, now so if you look at it, if you look at it, the history part of it, that is what actually has been done. The 12 really critiqued the history part of it. In comparison to others, like if other critical approach, I don't think any of them seriously engaged with the history part of it the way 12 has been doing it. In fact, that is also another dimension which 12 not only critiquing it but critiquing with a historical perspective. Yes.
So, since my area of interest is history of international law, but when we look at history being viewed from a 12 lens, there is a critique to that also, right? Because maybe Professor R.P. Anand or around the world, people who looked at history from a 12 lens did not give importance to caste, class, gender, right? So I would like to direct you to your contribution. I think one of the first on Twail and caste critique. So can you throw some light on that?
Yes. Now, probably it takes us to each methodological approach has its own worldview. It comes along with its own worldview. Probably it also comes along with its own limitations. So that challenge would be there probably if you look at the Marxist critique of international law. Others can challenge it, okay, it gives a primarily focus on class question. If you look at the feminist critique of international law, one can critique it saying that probably they are more concerned with question of women. And within that also, it is not gender in terms of gender in its kind of queer and other identities, but
the sexual subordinate, right?
So yes, then it only focuses on predominantly this gender binary of men and women. So that is a limitation to that. So in that sense, probably it is a valid critique against the trail that it ignored, and especially in South Asian context, as I said, the question of caste. And there are certain regional specificities which exist. The race is also a question important, which critical race theory has attempted to address it as part of the, particularly in the United States domestic law context, but that is equally important for international other race question. So yes, now there are certain limitations for every methodological framework. In that sense, the 12 also has those limitations, which probably we need to acknowledge those factors, and we also need to welcome the critique if it comes from any direction to that. So one is that, but there is a much deeper question to any methodological question, is that whether a particular methodological approach that we adopt, whether it fundamentally rejects other perspectives or other concerns. That I think we need to look at it carefully. Like for example, if to put it in a more concrete way, for example, by way of speaking, trail as a kind of making the colonialism a center to it, like largely the post-colonial studies do that. By doing that, whether it becomes a kind of rejects other possibilities of critiquing the one, then that is a major limitation to any perspective, in the sense that if you speak this, probably you can't speak the other, because structurally or fundamentally it rejects the other view. That would be a problematic one. But I don't think probably trail is such that where it is like not sensitive to other perspectives, but how to accommodate those things or how to expand the scope of trail's critique is a challenge. So one is that again that happens with every methodological framework, is that there would be some scholars who would believe that okay, trail is something which is essentially built on the idea of how the colonialism has impacted the world, not only the colonies but entire the globe, or people from every part of the world in every sphere of life. So therefore that should be the central lens through which we need to look at the field of international law. Is a not a wrong thing to argue that way. But if there are other concerns which are equally important ones, which are perspective like gender, like caste or a class, then the challenge comes in is that, okay, which is the priority? Now, do we need to prioritize something that, which to a large extent is also a political question, that like, what is the political priority in a particular historical context? Because that is a political question, that what is it that I want to give a priority to? Do I need to give a priority to the class or the gender? Or within the field of international law, what is the thing that we need to give priority to? Like, for example, today we need to give, we are confronted with the question of climate change environment. So should we really all focus on that and look at the whole field of international law, because this is a major concern. Now, these are some of the issues, but I see that the way trail is evolving, I think it seems to be that different perspectives are interacting. There is also strong critique coming in from various quarters of challenging the limitations that trail has. Probably we need to see how it takes its own path, but yes, I think at least there is a reception. There is a reception to the critique of trail. There is a reception to the other perspectives, how the trail has to interact with.
So, like in the present context, there are so many international conflicts that are going on, and somewhere people who are pursuing law, especially, they feel that international law, is it really at its vanishing point? Like, is international law relevant? Like, these kind of questions are coming back again, I feel, among the students at least. And in this context, when international law itself is being questioned, where do you put trail in this situation?
Yes, now any major crisis happens at the international level. Of course, one of those fields which is always questioned is that, okay, what international law does to this? Like, if genocide is happening somewhere else, people are being killed based on the identity, the cities are being bombed, civilians are being targeted, what international law is doing? And which is a very genuine question coming from any common person, that it should do something, and if it is not doing something, that what is its relevance at all? But interestingly, if you look at it, most of the, at least if you take two conflicts that are taking place now between Israel and Palestine, Hamas and Russia and Ukraine, good amount of attention that is given in relation to these conflicts is about legal issues. Like, for example, if you see the ICC, International Criminal Court, issues arrest warrants, then there is so much of a media attention comes into that. Or International Court of Justice issues advisory opinion about Palestine. There is so much of discussion is happening about the whole idea of what constitutes occupation. When does occupation turn into an unlawful occupation? Now, these are all the questions of international. Actually, without being called as international law, even from the political class to the other sections, are engaging with the question of trail, so international law. So therefore, international law somewhere comes into the picture. But the fundamental question remains is that, okay, if it is so central to everyday discussions, what is its impact on it? And now that is where comes the relevance of the critical method like trail. Okay, why it is not able to deliver the promise that it makes. So therefore, that is where the trail critique comes into picture, bringing the history. Like, for example, if most of the discussions about Palestine starts with the October 7 incident in last year, where Hamas went and attacked Israel, then from Israel started doing it. But the question is that Palestinian history doesn't start on October 7, 2023. It goes back to 1967, it goes back to 1948, it goes back to 1917 Balfour Declaration. So there is a long history to it. And how the whole concept of mandate system was evolved post First World War, and that has been extensively worked by trail scholars critiquing the mandate system as so that is where the trail comes into the question of Palestine. So this is a lens which many of the scholars have been writing now on this. Most of the work on Palestine, in fact, takes a critical lens, and there is a huge contribution from the 12 scholars who have worked on the question of Palestine in relation to mandate system and the question of colonization or other forms of colonization, not only the classic forms of colonialism. So these are central to the matters relating to the conflicts today. And the same is the case, for example, with Russia and Ukraine, if you take it. So it's not that something that history starts yesterday when the conflict started. So there is a long history to it, which is, of course, the Second World War history, then closely also linked to the entire the Soviet Union's experiment with its own political larger project. And the Cold War. So all of them are linked to it, and how NATO kind of institutions play a role which is closely related to the concepts like use of force.
Yeah.
So how the use of force has been subjected to different modifications in practice by states, especially for the global north and Western European states, which is very central to the what is happening today in both the conflicts. So therefore it is important, it is being discussed. Yes, not always it is said that okay, this is every time it is a 12 perspective or a critical perspective, but that is what these critical perspectives are able to do that. Even there is also scholarship that how probably whether these legal developments, because that is also a critical perspective, is that whether too much of legalization of these conflicts does it really serve the people on the ground also is a question, which is also a critique that like do we need to move away from over legalization in terms of going to the International Criminal Court, going to the International Court of Justice, somebody goes to the European Court and talk about more about General Assembly resolutions. So it goes on, and somebody would see it, okay, that is nothing is coming out. Like people are suffering is continuing. What do you do? But yes, the trail and other critical perspectives are engaging with that. I think they are important in terms of critiquing it.
And what do you think are the gaps that are left in TWAIL research, or new emerging areas which are not being explored by TWAIL scholars?
Yeah, actually there are many. As I said in the beginning itself, probably I think the history part is being done fairly substantive way from the critical perspective of the TWAIL, but there are many areas which are very important. Actually, for example, a lot of third world assertions in relation to some of the developments in the field. Some of the developments have happened, like for example, law of the sea. Now, if you look at the field of the law of the sea, that was one huge codification exercise which had taken place, and most of the negotiating work was influenced by the Third World Assertion in 1960s and 1970s, and which culminated in the adoption of the convention in 1982, and the Global North was adamant on diluting it, which led to the 1994 adoption of the agreement. And now, probably I think the serious efforts are being made towards exploration and exploitation of the area. Now that is one aspect to it. So exploration has already started, and this is again going to pose major challenges to the field of international law now. Like, what are the consequences of this exploration and exploitation in terms of because law of the sea is going to closely interact with other fields of international law, like investment law, environmental law, because it may lead to the pollution and others. Now these are the areas which probably even within the field of law of the sea, where the influence of the third world was immense, now again probably we need the younger generation, the scholars, they have to work extensively on that. The other aspect, for example, international space law, if you look at it, there are also efforts towards going for exploration and exploitation of the space resources, and that is one area where there is a codification exercise started, and which is limited to 5 international treaties, but many things are left out. Like there's a concept of common heritage of humankind, which is also taken into the international space law, but that is thought to be diluted by the developed countries now in relation to international space law. So that is one area which requires it. In addition to many of the very old areas, like in what we call quote-unquote standard international law, like for example international humanitarian law. I don't see much of a critical engagement with international humanitarian law itself, like the fundamental categories of who is a civilian, though again addition protocol 1 kind of developments were immensely influenced by the assertion of the third world countries in 1960s and then 70s again. So, but there is a vast area is left, like, so it's not only those areas which in fact are emerging where the critique is very much needed, but even those areas which in fact are considered as part of international historically need further explanation. From the 12 perspective, because there is a huge work which needs to be done in terms of the critiquing it. Though of course there are good number of at least a fairly good number of scholars are working from the critical perspectives, including the 12. On some of the history part of it, but even for example use of force, like how really, what kind of state practice in relation to use of force needs to be looked at, critiqued at, what kind of development that have taken place in the last 2 or 3 decades with regard to use of force. There are many, in fact, many in terms of, because one thing is very clear when we talk about critique. Within mainstream, if you look at it, there are many nuances which we need to recognize it in a doctrinal sense. And this nuanced way of looking at international law, developing different doctrinal perspectives continues to happen because the mainstream international lawyers continue to do that. Therefore, there is every possibility for every issue to critique it.
To be revisited.
So therefore, because it's not that something that mainstream international lawyers stop thinking. No, they keep thinking. They keep inventing. They keep inventing. They keep inventing in relation to every issue. So there is every time a doctrinal innovation comes in with a mainstream understanding. So therefore, that requires a critique. So it is not that something that it is done. No, it is a work. Always is a work in progress.
So we need more dwellers to explore more and more international laws that are emerging areas. So what do you think? Like very few scholars have worked on environmental law from a 12 perspective, I would say, especially looking at the idea of climate justice and those issues. So since our theme also intersects with not only diverse perspectives of international law, but connecting them to climate justice. So what is the stance that the dwellers should adopt? Even though there are few works, but not much, I would say, from the 12 perspective on environmental law, I think.
Yes. Particularly about, because I really do not follow the everyday development that happen in the field of environmental law. But if one has to look at generally, even as an outsider to the field, environment, climate change, of course the 12 perspective is extremely important, but it is also something which I think we need to pause and think that, okay, when we look at the field of environmental law, or critiquing environmental law, the way it emerges, probably the economic dimension of or the economic foundations of what is happening around in terms of environment is important. So which essentially takes us to the question of what capitalism does to the environment. So probably it becomes important for us that the economic dimension of what is happening to the climate or environment is equally important along with what we look at from the 12 perspective. I'm not saying that the 12ers are not concerned with the economic dimension part. It is an extremely important one. But I think it is much more also one has to look into it and see that how the capitalism, the way it works, or it worked historically, including from colonial times till today, have contributed to what we are facing today as an environmental crisis. So therefore, I think probably that is where it is important that the trailers, those who are doing in a limited way and those who want to do it, need to look at it a little more expansive way to what is happening with the environmental law. That is what I feel that probably there is a scope. I mean, it's not the scope. There is a huge possibility to look into that. But I think the economic dimension in the case of environment becomes much more probably than other things, other branches of international law that we look at it. So.
It's more connected because natural resources and those kind of things are central to this. Now, as we are about to end the program, finally, as what would you suggest to our readers? Because our theme is human rights, critical human rights, and what would you suggest our readers to depend on when it comes to critical human rights law? Because you have had decades of experience on human rights, humanitarian law, and now mostly criminal law. So can you share some resources which they can
so one is, of course, a general, we keep emphasizing it in our classroom discussions also, is that whenever somebody writes or trying to write an article or reflecting on something, look for as much as possible if there are any writings which have come from the global southern scholars, like what they have said about a particular issue, at least, which is a general one, like whether there exists something written by a scholar from this part of the world. Probably they might not have been written in a big established journals or established publishers, but there must be views. Or they may not be the views exactly in law, but in related disciplines there must have been already views. So therefore that is very important, that somewhere I think we need to explore the possibility of those ideas which have already emerged in this part of the world and the writings. And there are, in fact, that is what many of the scholars are doing, that what is looking at the scholars from this part of the in contemporary writings like human rights, like you and Tamil have edited a book with regard to human rights, which is
critical,
which is very important. Then at least it is taking the debates further, and then again the younger generation would pick up those issues which are left out then further. So as a general one, always look for, if there are, I'm not saying that it is like, it should not also be seen as that we are very parochial, that we are only emphasizing. No, we are not saying that you should not look at the writings coming from the global north. Or, that is not the question. That is there. So there, the question is that you have no option to ignore that. It exists there. The only thing is that we need to explore the possibilities of knowing things from this part of the world, the global south. As a kind of narratives which are what are there. I'm not saying that everything that is produced in this part of the world is great. No, there are issues. There are many ideas which are equally hegemonic in global southern part. There are hierarchical social structures which exist, gender, as we discussed about caste. So there are many issues which are equally problematic in this part. So therefore, it's not that just to celebrate everything that is global south. That is not the point. But at least even to critique that, we need to know what is said here. Because the unfortunate part of it is that these ideas were not seriously engaged with. It's not the question of celebrated about, but we need to engage with those ideas which emerged and which are emerging from this part of the world. We need to seriously engage with those. I think that is a starting point which I'm not saying that again, that you don't need to subscribe to everything that comes from this part of the world. There are many ideas which have global north, Europe, contributed to the world of ideas. Since this has not been recognized equally, probably that is where I think we need to start emphasizing more on looking at it. Whenever we write, whenever we speak, just pause and see that, okay, there is whether something exists in this part of the world. I think that should be the starting point, which would help at least to bring ideas, and it may be taken forward.
Thank you so much, sir, for discussing and enlightening us, especially on third world approaches to international law, which remains one of the best critiques of international law till date, and will continue to do so by encouragement from teachers like you. Thank you so much for being part of ESDR also. Thank you.
Thank you.